Thank you. Court calls the case People versus Thomas Vasher.
Escalating for people.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Vasher.
Your name?
Thomas Vasher.
All right, what are we doing?
Your Honor, we are requesting an adjournment to obtain some media discovery, and when appropriate, my client would like me to address bond.
He has a bond. Hey, do you have the bond violation report?
I do not have the bond violation report.
This just came in.
Oh, then if it just came in, I would not.
A bond violation.
I don't know.
It's a report that just you.
Oh, you know.
Oh, that's my handwriting.
No.
That must have-
Oh,
I don't,
You didn't remember.
yeah, that might be why he's in custody.
Right. That
Got it. Okay, got it. All right. Probable cause conference, June 12th, 2025, 9 a.m. As to bond.
as to bond, Your Honor, I'll be requesting a PR bond on behalf of Mr. Vasher for the reason why he missed his last probable cause conference court date. It did appear he was in communication with our office. He did talk to one of my colleagues. They were going to request an adjournment, and he misunderstood, thinking that meant he would, that mean that he didn't have to show up to that particular court date. So we do have good contact information for him. He is being supported by his church and has been attending programming from Home and New Vision. So I would be requesting a PR bond.
You're sponsoring the people?
Your Honor, I do believe the defendant is on probation under the 22nd Circuit Court for assaulting, resisting, or obstructing a police officer. In this case, he was taken into custody, I believe, for a warrant related to that probation. And when he was arrested, he was found to be in possession of several different individuals' IDs or cards, or credit cards of this nature. So I do not think a PR bond is appropriate, and he did have a failure to appear.
Anything else?
I said, I was reiterate, I know he has a support system. He will be appearing in the court. We do have good contact information for him, and I would be requesting that.
What do you want to say, Mr. Vash?
Mr. Simpson, Your Honorable Judge, I just want to inform you that every day of my life, I get up and I live with that lady in the back there in the court, and I get on my bicycle and I ride right there, the little lady right there. And I ride my bicycle every day, and I pick up garbage out of churches and school parking lots, and that's where I find
I would advise him stop making any statements, because those could be used against.
Well, that's just the truth. That's where I even got the credit card.
I would advise you stop making that statement.
I've done everything right. I'm doing good. I'm really, for the first time in my life, proud of myself.
I've set this out to the 12th. I'm going to deny the request for a change in bond at this juncture. Is he going to be dealing with the circuit court matter anytime soon? Violation?
I'm not sure of his court date off the top of my head. I would have to check.
Okay. So his bond at this point will continue. Thank you.
So PR bond?
Your bond's continued. It's not a PR bond.
It's not a PR bond?
Your bond's being continued.
I've been doing everything right, Simpson. Everything. Everything I'm supposed to do.
Okay, you keep talking at me, it's going to get worse. Okay, thank you. People versus Stephen Johnston.
Okay, Rachel McDuffie for the people. Here to go. And Allison on behalf of the people, Your Honor.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Johnston.
All right. I put this over to this afternoon. What have we determined?
Yes.
Good evening. Well, good afternoon.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to the circuit court. I will have him fill out that form momentarily, Your Honor. So he's waiving up? Yes, he'll be waiving up. All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name.
Can we come from?
Yes. Go ahead. Mr. Buckers. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Kunke there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, between the time of Judge Kunke's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
Well, context may be changed. He has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a violation of his previous probation. So
right, okay, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr. Buckovich?
yes, I would understand what you're saying, yeah.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. He's waving up.
Yeah, we get you in front of Kunke.
You know what, Your Honor, I might as well just wave up to Kunke.
Okay.
Okay, if that's what you wish to do. Sir, you
Tells me addressing bond and not changing bond. It was no contact with her. That's what I was addressing. I'm not going to be right door shooter. That's not the good word. But you don't be innocent. The best we addressed it. We are addressing contact. Surprise. That's my fiancée. Yes, ever did that.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening. So I would still be asking for a...
You're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Odosella, Mr. Bukovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and Magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his phone privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised a red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now. So the people are, again, requesting a simple but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
All right, here's what the court's going to do. Well, is he waving up or what's he going to do?
Mr. Funky?
Or did you wish for the adjournment, Mr. Frank?
Your Honor, I'm quite confused on a couple of things. If I'm able to speak to you for a second, the complaining witness of who they are talking about. I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke, Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Kunke's courtroom, Your Honor. And by me not being able to have contact with her, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with a.
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did, are problematic.
What she did?
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm not able to have contact with her. She didn't put me in this predicament. Her doctor
Sir,
did a
I advise you stop
welfare
making
check.
statements. I advise you stop making statements because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No,
do the
give me
waiver?
the pen.
Yes.
I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm not
get it.
taking his waiver. I'm just going to adjourn this out. You can talk to your client. He can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me.
I'm not.
I don't even know why. I'm making the findings based upon what's presented to me. But if he's going to act this way, I'm just not having it. So
Would you like to briefly pass this matter so I can speak to
no,
my client? Your
I'm
Honor?
not going to pass it. I'm going to adjourn
not
this to
mad.
another
Oh.
day.
I'm not mad.
I'm going
Not
to
upset.
adjourn this to give him 1 week out. We'll go June 5th, 2025, 9 a.m.
Mr.
or his
Simpson.
invite indicates. I am at this time going to change the bond conditions. I'm going to leave his bond in its monetary amount as it's set. I am going to order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also going to indicate that there's no contact with Christian. I'm going to order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm going to put up with his behavior, I'm not doing it. I'm
Your
done.
Honor,
Thank you.
I'm not upset, Your Honor. I said just. Okay. Not even upset at all.